Hi there. I'm attorney Abigail Poole, and I work at the law firm of Samuel Sayward and Baylor in Dedham, Massachusetts. We're a law firm that concentrates our practice in the areas of estate planning, elder law, probate, and trust administration. Today I'm here with my colleague and also new partner to the firm, attorney Julia Abbott. Julia, did you want to say a few words?
Sure. Good morning. Thanks, Abby. I'm delighted to be here. I am a new partner with Samuel Sayward and Baylor. I joined in February of this year. I've been practicing in the areas of estate administration, elder law, and estate planning for about 15 years, and I'm delighted to be here. Thanks, Abby.
Great. So today's video is a follow-up to a Smart Counsel webinar on the Secure Act that we posted on May 21st. So if you haven't seen that video yet, I recommend that you watch it first because it has a lot of the foundational concepts that we're going to be discussing today as we answer questions that we received from clients after watching that video. So without any further ado, I'm going to pass it over to Julia to get us started on the questions and answers.
Great. Thanks, Abby. So the first question we received was, I am age 71 now in 2020. Do I need to start taking required minimum distributions from my retirement account? So the answer to that is the Secure Act, which went into effect on January 1st of 2020, extended the age that you have to start taking your RMDs to age 72 when it used to be age 50 and a half. So that's the short answer, but also it's important to take into account the CARES Act, which was also recently enacted, which says that if you are impacted adversely by COVID-19, you may not have to take your RMD, even if you are age 72 in 2020. So the answer is you should certainly consult with your financial advisor and CPA to determine whether this is something that you need to do in 2020. All right, question number 2 was, can a donor advised fund be a contingent beneficiary on a retirement account? And the answer is yes. And if you're not familiar with what donor advised fund is, it's like a charitable investment account for the purpose of supporting charitable organizations that you care about. When you contribute cash or securities or other assets to a donor advised fund, you are usually eligible to make an immediate tax deduction. Then those funds can be invested for tax-free growth, and you can recommend virtually any IRS qualified public charity. Although designating any qualified public charity usually allows an estate to claim a charitable contribution deduction, naming a public charity with a donor advised fund as a beneficiary of an IRA or a 401k gives your clients or our clients and their heirs more flexibility. Upon death, your IRA assets can fund a donor advised fund. It can then be distributed to charities immediately or over time through an endowed giving fund or program. Or you can let a trusted friend or family member make the choice, or a designated account successor can then make grant recommendations over time to the charities that they would like to support. Abby?
Okay, great, thanks. So one of the questions that we received is, we are in early 40s, have minor children, and our largest assets are our home and IRAs, 401ks. Do you recommend that we have a trust? So everybody's situation is different. And we always look at all of your assets in their totality, and then we also look at and consider what your wishes are and goals and your needs, and then also what the values of all those assets are. So your estate planning attorney is going to walk you through a variety of questions and also scenarios to really figure out what's most important to you. Once that's done, it may be that a trust, one or more trusts, might be the best fit for you. And that's especially the case when you are looking at having minor children as the beneficiaries, especially on retirement accounts, because especially if your accounts are significantly large, that you wouldn't want your children at the age of 18 or 21 getting that money or having access to that money, then we would want to consider doing a trust for you. On top of that, trust can also be beneficial so that that person is managing those funds for your minor child. And then also after they turn 18, 21, 25, if you want to make sure that the money is managed and controlled and distributed out to them in a way that you are comfortable with in the event both you and your spouse pass away. So it looks like question number 4, Julia.
Right. So question number 4 was, would you please further explain the difference in required distributions to non-compliant trusts based on the deceased's age, so the deceased owner's age? And this is the 5-year rule versus ghost life expectancy rule that we talked about in our initial webinar. This distinction really comes into play only if the beneficiary that you named does not qualify as a designated beneficiary. So remember, a non-designated beneficiary would be an estate, a charity, or a non-designated beneficiary trust. If the owner of the retirement account dies having named a non-designated beneficiary before he or she started taking his or her RMDs, required minimum distributions, then the beneficiary of that account must withdraw all assets within 5 years of the owner's death. That's the 5-year rule. If the owner of the retirement account died on or after his or her required beginning date, the beneficiary must withdraw the account assets over the owner's ghost life expectancy rule. So what does that mean? So if the owner died at age 75, and according to IRS publication table 590-B, had 13.4 years life expectancy, the beneficiary is required to withdraw all assets from that account over that 13.4 year period. So again, the ghost rule versus the 5-year rule only comes into play if the owner had named a non-designated beneficiary as the beneficiary of his or her retirement account. Abby, back to you.
Great, thank you. So the next question is, we have conduit trusts that state that the trustee must withdraw the minimum required distribution under Internal Revenue Code section 401A9. Does this wording make our trusts non-compliant with the Secure Act? So the wording itself does not make the trust non-compliant. Reference to that particular section should be in your trust and is likely to continue to be referenced in your trust, even if you had accumulation provisions. So what that section basically says is it generally states that the requirements that are to be considered a beneficiary, including designating a trust, and also the provisions of a retirement plan that are necessary to qualify it under the law to make RMDs. So continuing to have conduit trust provisions in your trust may be okay, as long as you understand that the Secure Act may change the required distributions to your beneficiaries and you're comfortable with those changes. So for example, the beneficiaries may receive larger distributions over a much shorter period of time. There are certain administrative provisions that will need to be reviewed to make sure that they're in compliance with the Secure Act. So, and that they do not trigger that 5-year ghost expectancy rule versus the 10-year distribution period. So the best way to do that is to be in touch with us and to schedule a call or video conference with your estate planning attorney, whether it's Sue, Maria, Julia, or me, and to review your trust in light of the Secure Act, and then to make specific recommendations regarding the changes that would best suit your estate plan goals and wishes. The next question is the following. I have an adult child with special needs who doesn't handle money well, and some of my assets are retirement accounts that I want her to get. Are there estate planning options available to protect the retirement accounts for her use? So the answer is yes. Something called a supplemental needs or special needs trust that can be created for your estate plan to benefit your special needs adult child. There's several different types out there, but one type can be funded at your death with assets, including retirement accounts, for the benefit of your adult child. They're especially helpful when you anticipate or your adult special needs child is already on public benefits such as Medicaid, SSDI, etc. Because what the special needs or supplemental needs trust can do is basically direct that the money held in the trust is protected and only really available to supplement any public benefits that your adult special needs child is getting already. So it would cover expenses and activities that are not otherwise covered by public benefits. The other benefit of having that supplemental needs trust is that under the Secure Act, it's possible, depending on the situation of your adult special needs child, that she may qualify as an eligible designated beneficiary because she is deemed disabled or chronically ill. And if that's the case, it means that that 10-year rule that the Secure Act has created doesn't necessarily apply to her. She might be able to get the distribution stretched out over her life expectancy, which would be beneficial for her. And I believe it is back to you, Julia.
All right, so the last question that we received was asking us to expand on the benefits of converting to a Roth IRA in light of the Secure Act. So a Roth conversion involves transferring money from a traditional IRA or other retirement plan to a Roth IRA. However, conversions usually trigger an income tax bill that can be substantial. But once the money is inside the Roth, future withdrawals are tax-free. In addition, there are no required minimum distributions from a Roth IRA. Still, it doesn't make a lot of sense to pay a big tax bill now if the money can be accessed at a lower rate later. And that's the situation for most people, since their tax brackets will drop once they retire. Another consideration when contemplating conversion is that people need to be able to pay the tax bill out of their current income or from other non-retirement accounts. Conversions can make sense if the IRA owner expects to be in the same or a higher tax bracket in retirement. So good candidates for Roth conversions tend to be young savers who expect their incomes to increase over the years, and older people whose tax bills could increase when they start taking required minimum distributions. So conversions can also be appropriate if the money is intended for heirs whose tax bracket is likely to be at least as high as the account owners. A retiree may not want to convert if the money will likely go to young grandchildren or other heirs in lower tax brackets, for example. But if money left to an heir in her peak earning years, conversion may be wise, especially now that inherited retirement accounts have to be drained within 10 years. So an ideal time for a Roth conversion can be after retirement, but before required minimum distributions begin. Tax brackets often dip during this period, and the conversion can be spread over several years to better manage the tax bill. The higher age for required minimum distributions, so 70 and a half to 72, also gives people more time to make these conversions. It's really important, though, that you discuss this decision with your financial advisor and accountant. There are traps for the unwary, and your advisors will be able to identify them and help you determine whether this is an appropriate planning strategy for you and your family. So those are the questions that we received based upon our webinar. And the next question is, what now? So the bottom line is, if you have large retirement accounts, please call our office and schedule a call with us to discuss the implications of the Secure Act on your plan and your beneficiaries. And if your retirement accounts are payable to a trust for your beneficiaries, it is crucial that we take a few minutes to review the trust and ensure that it is brought into compliance with the Secure Act if the benefits are going to continue to be paid to the trust. So that is our question and answer seminar. If you have additional questions or concerns, we invite you, we encourage you to call the office, speak with Jennifer or Ed, and make an appointment for a telephone call or a Zoom call to ensure that we can review your trusts and make any revisions that may be necessary in light of the Secure Act. Abby, any final closing words?
Nope, that's great. Thank you very much. Take care, everybody.